Hello everyone, welcome back to Legally Dephine and a warm welcome to all our new members. This is Legally Dephine Law Simplified. Take note that we have already covered 3 videos on marriages. Make sure to check them out so that we can catch on. In this video, we are going to look at the solemnization of civil marriages. Let's get into it. After the preliminary requirements such as the notice of intention to marry, the publication of bonds, and the obtaining of a marriage license have been complied with, and no objections has been raised as to the age, the legal capacity, and relationship of the parties, finally, the marriage may proceed to solemnization. As we discussed earlier, a civil marriage must be solemnized by an authorized marriage officer. The Act also provides for where and when the marriage should be solemnized and who should be present. Section 30 of the Marriages Act provides for the time and place for and the presence of parties and witnesses at the solemnization of a marriage as follows. A marriage may be solemnized at any time. A marriage officer shall solemnize any marriage in a church or other building used for religious service, or in a public office or private dwelling house or other place approved by such marriage officer, in the presence of the parties themselves and at least 2 witnesses of or above the age of 18 years. No person shall, under this Act, be capable of contracting a valid marriage through any other person acting as his or her representative. The most important point to note on Section 30 is that parties to the marriage must be there in person with at least 2 witnesses who are 18 years or above, and that a person cannot send a representative to contract a valid marriage on their behalf. Here is why witnesses are important at solemnization. Number 1, they provide independent confirmation that the parties appeared before the marriage officer. Number 2, they provide confirmation that the parties freely consented to the marriage. And number 3, they provide confirmation that the prescribed marriage formalities were followed. If misunderstandings happen in the future, witnesses may be called upon to confirm that the marriage ceremony actually took place. The marriage formula is the statutory declaration prescribed by Section 31 of the Marriages Act. It requires each party to first declare that there is no lawful impediment to the marriage and then publicly accept the other party as their lawful spouse. This formula serves as evidence of consent, capacity, and intention to enter into the marriage relationship. So the Act provides 2 parts, the first of which is declaration by each party. This is the declaration each party must make. I do solemnly declare that I know not of any lawful impediment why I, A.B., may not be joined in matrimony to C.D. here present. This declaration confirms that the person knows of no legal reason preventing the marriage from happening, such as another existing marriage, being underage, or a prohibited relationship, or any other legal impediment. The second part of the formula is exchanging of marriage vows. So, after saying the declaration, each party must then say to the other, I call upon these persons here present to witness that I, A.B., do take C.D. to be my lawful wedded wife or husband. This is the actual acceptance of the other party as a spouse in the presence of witnesses. After receiving declarations, the marriage officer then pronounces them as legally married. This pronouncement is significant because it marks the moment at which the marriage legally comes into existence. So, after the declarations and the exchange of marriage vows, this is where the marriage officer now says the iconic phrase, I now
pronounce you husband and wife.
Exactly. Now, let's briefly go through the reasons why we have a marriage formula. Number 1, it confirms the absence of legal impediments. Number 2, it demonstrates free and voluntary consent. Number 3, it provides evidence of the parties' intention to marry. And finally, it forms part of the formal solemnization requirements for a valid civil marriage. Just think of it as a final checklist for solemnization of a civil marriage. One interesting point to note on Section 31 is that it allows ministers of religion to follow the rights of their denominations when it comes to these declarations. But magistrates and other marriage officers must use this formula provided for in the Act. A blessing of a marriage is a religious ceremony conducted by a minister of religion after a civil marriage has already been solemnized and registered for the purpose of giving religious recognition to the marriage without creating a new marriage or altering its legal status. Section 34 of the Marriages Act allows parties who are already legally married under a civil marriage to have that marriage blessed by a minister of religion. Section 34 of the Act provides, nothing in this part shall be construed as precluding a minister of religion or a person holding a responsible position in a religious denomination or organization from blessing according to the rights of his or her religious denomination or organization any marriage contracted within or outside Zimbabwe, or making such entries and issuing such documents as may be required by rules or regulations made by his or a religious denomination or organization in connection with the religious blessing of marriages, if such entry or document does not purport to have been made or issued in terms of this Act. A minister of religion acting in terms of this section shall inform the parties that the blessing of a marriage does not create a marriage as defined in this Act. Let's simplify this. Section 34 is saying that after a couple has completed or has gone through the solemnization process of a civil marriage in terms of this Act, they may then choose to go for a religious blessing of their marriage. That is allowed by the Act. But take note that a religious blessing of a marriage alone without the actual proper solemnization in terms of the Act does not constitute a valid civil marriage. It is also important to take note that other denominations may issue out certificates for blessing of a marriage. That is also allowed by the Act, but those certificates do not constitute actual marriage certificates. You have to get an actual marriage certificate in terms of the Act, which is the Marriage Certificate 5.17. So, from choosing that the type of marriage you want is a civil marriage and having satisfied all the requirements for a civil marriage until solemnization of that marriage, the next step which now follows is the registration process, and that's exactly where we are headed. If you have watched until the very end, thank you so much. Make sure to subscribe, like, and share, and until next time.